Picture this. In 9 U.S. states, owning the very magazine that likely came standard with your handgun, one that holds 15 rounds, could now put you on the wrong side of the law. That's not fear-mongering. It's the new legal reality following a major ruling by the Ninth Circuit Court of Appeals in the case known as Duncan versus Bonta. This isn't just a California issue. This federal decision carries implications that could reshape how arms are interpreted under the Second Amendment across the country, and not for the better. According to the court's logic, magazines above a certain capacity aren't essential, aren't constitutionally protected, and therefore can be prohibited. If that sounds contradictory to you, you're not alone. This ruling reflects a broader legal tactic aimed at chipping away at gun rights bit by bit. In this video, we're going to break down what led to Duncan Bonta, the reasoning behind the court's conclusion, and why every gun owner, no matter where they live, should be paying close attention. This case is part of a strategic legal effort to redefine firearm rights through incremental changes. You might be asking yourself, why should I care if I don't live in California or fall under the Ninth Circuit's jurisdiction? It's a fair question, but here's the catch. Federal appellate decisions like this one don't exist in a vacuum. Other courts often look to them for guidance, and over time, their logic can spread, influencing judges in other circuits and eventually landing before the U.S. Supreme Court. That's where things get dangerous. Once one court successfully argues that detachable magazines holding more than 10 rounds aren't crucial to how a firearm operates and thus not protected as arms, it sets a precedent. That opens the door to further reinterpretations. Today, it's magazines. Tomorrow, it could be optics, stocks, or even trigger upgrades. Where do we draw the line? That's why Duncan v. Bonta is more than a single legal case. It's a litmus test for how far government regulation can reach when it comes to what law-abiding citizens are allowed to own. If this kind of legal reasoning isn't challenged now, it's unlikely to stop at magazines. To fully grasp what's happening today, we need to go back to 2016 when California enacted Senate Bill 1446. This law prohibited the ownership of so-called high-capacity magazines, defined as those holding more than 10 rounds. That same year, voters backed Proposition 63, which went even further by adding criminal penalties for possessing these magazines even if they were legally owned before. This sparked immediate controversy and concern among gun owners. The California Rifle and Pistol Association responded by filing a lawsuit in federal court. Their argument? That these magazines are standard equipment used by millions of Americans for lawful reasons such as home defense, recreation, and competitive shooting, and banning them violates the Second Amendment. They initially scored a win when U.S. District Judge Roger Benitez ruled in their favor, striking down the ban as unconstitutional. But the state wasn't done yet. California quickly filed an appeal, pushing the case up to the Ninth Circuit Court of Appeals. Instead of a typical panel of 3 judges, the case was taken up en banc, meaning it was reviewed by a much larger group of active judges. Given the Ninth Circuit's historical leanings, the outcome became fairly predictable. This move shifted the case from a straightforward constitutional review into what many see as an act of judicial activism. The court's final ruling spanned 148 pages and claimed that magazines holding more than 10 rounds aren't protected under the Second Amendment. The judges argued these magazines are just accessories, not essential components of a firearm. Their logic was that if a gun can operate with fewer rounds or even be loaded 1 bullet at a time, then larger magazines aren't necessary and can legally be prohibited. But this kind of reasoning sets a troubling precedent. It opens the door for courts to decide what parts of a firearm are essential which could extend to other components in the future. Instead of repealing the Second Amendment outright, this legal approach aims to redefine what counts as a protected arm, effectively narrowing gun rights through redefinition. Not all judges agreed with this interpretation. Judge Van Dyke wrote a dissenting opinion and even released a video to explain why he believes this ruling is deeply flawed and dangerous. His stance reflects the seriousness of this legal battle and how much is at stake. Let's take a closer look at the broader legal strategy behind these rulings. It's not just about magazines, it's about reshaping how courts interpret the Second Amendment. One tactic being used is to misuse the not in common use phrase from the District of Columbia versus Heller decision. Originally meant to restrict bans on weapons not typically used for lawful purposes, it's now being used to argue that anything not sufficiently widespread according to their standards can be outlawed. This logic could be extended to items like suppressors, short-barreled rifles, or even certain pistol configurations. It doesn't matter if the item is effective or commonly used in defensive scenarios. If it's deemed uncommon, it becomes vulnerable. We've already seen machine guns labeled as dangerous and unusual. Now short-barreled rifles are supposedly not in common use, setting a pattern. If this continues, they might argue that AR-15s with special triggers or Glocks with threaded barrels fall into the same category. Worse still is the emerging idea that if a firearm can be modified into something dangerous, that alone could justify a ban. Recent lawsuits against Glock, claiming their pistols are unsafe because they can be turned into automatic weapons, demonstrate how this thinking works. If courts accept that argument, then nearly every semi-automatic firearm could be at risk, not for what it is, but for what it might become. This is the strategy: slowly chip away at Second Amendment protections by redefining and restricting what counts as protected. It brings us back to the current fight over magazines. If the anti-gun side succeeds here, it will open the floodgates to regulating almost every component of a firearm. Let's now unpack the idea of common use, a key pillar in the legal argument made by the Ninth Circuit. Their reasoning hinges on the belief that magazines exceeding 10 rounds are not commonly used for lawful purposes. But is that actually supported by the numbers? In reality, around 70 to 80% of all magazines sold in the US exceed that 10-round threshold. These aren't exotic attachments. They're the standard issue for most semi-automatic handguns and rifles used in self-defense, sport shooting, and home protection. If the vast majority of firearm owners are using magazines of this capacity, how can they possibly be labeled as uncommon? That's like claiming SUVs aren't widely used because some people drive hatchbacks. This flawed logic helps avoid triggering constitutional protections. After all, acknowledging that these magazines are normal would undermine the entire legal basis for banning them. That's why many advocates use the term standard capacity instead of the misleading high capacity. When a certain configuration dominates the market, calling it excessive is nothing more than rhetorical sleight of hand. And outlawing what's standard isn't regulation, it's outright prohibition. Now let's examine the most concerning part of the Ninth Circuit's argument. The court concluded that magazines, especially those holding over 10 rounds, aren't vital to a firearm's basic function because they deem them non-essential. The court argues they fall outside the definition of arms protected by the Second Amendment. That line of thinking is dangerous. Just because a gun can fire a single round without a magazine doesn't mean it's functioning as designed. Would you consider a car fully functional if it only ran in first gear? The court essentially equates magazines with non-critical gear like slings or flashlights, optional add-ons that don't warrant constitutional protection. But that perspective ignores real-life application. Relying on a handgun with a 1 or 5 round magazine in a defensive scenario is not only unrealistic, it could be fatal. Magazines aren't decorative. They are central to how modern firearms operate. Judge Van Dyke made this point crystal clear in his dissent. If magazines are non-essential, what's next? Banning optics? Grips? Trigger upgrades? The slide? This interpretation opens the door to a piecemeal dismantling of gun rights. If non-essential becomes the standard for prohibition, nearly every component is at risk. This legal framework isn't about improving public safety. It's about exerting control over what law-abiding citizens are allowed to own. Magazines are part of a firearm's basic function and are used precisely as the designers intended in real-world situations where reliability and readiness matter most. It's also important to recall what the U.S. Supreme Court has already made clear. The Ninth Circuit's decision flies in the face of what Justice Scalia established in District of Columbia v. Heller. In that landmark case, Scalia didn't invent a definition of arms, he relied on centuries of historical context. According to Heller, arms refers to any weapon or tool carried for defense, something one might wear, carry, or wield in battle. That includes more than just the gun itself. Take the Colonial Minutemen, for instance. When they assembled at Lexington and Concord, they didn't just bring rifles, they brought powder, cartridges, pouches, and other vital accessories. These tools were inseparable from the weapon system and essential to its effectiveness. Likewise, in modern times, when someone trains with an AR-15, their optic, sling, and standard capacity magazine are not extras, they're integral to the firearm's intended use. Trying to isolate these parts and declare them unprotected is like saying the First Amendment covers free speech, but not the internet. The tools evolve, but the rights don't vanish because of it. That's the legacy of Heller, and it's what's currently under attack. As cases like this move closer to the Supreme Court, it's crucial that this constitutional framework isn't abandoned. If we lose the definition of what qualifies as a bearable arm, we risk losing the protections that come with it. The ongoing fight over magazine restrictions isn't happening in a vacuum. It's just one front in a larger legal campaign aimed at dismantling Second Amendment rights bit by bit. This kind of coordinated legal pressure, often referred to as lawfare, is being waged on multiple fronts, and one of the current targets is Glock. You've probably come across the lawsuits where various cities and states are going after the company, accusing it of negligence. The claim? That Glock pistols are too easily modified with aftermarket parts to fire full auto. Because of this alleged ease of conversion, they argue, Glock should be held accountable. But don't be fooled, this isn't just about Glock. It's a calculated move designed to set a precedent that could affect the entire firearm industry. If the courts accept that a semi-auto is too dangerous simply because it could be modified, then nearly every firearm on the market becomes a target. Once that legal logic is accepted, it can be applied to other guns, other manufacturers, and eventually any platform with modular or customizable components. Anti-gun groups are laying the legal groundwork to strip protection from anything they can call easily convertible, pushing it into the category of dangerous and unusual, which isn't protected by the Constitution. This is why magazine restrictions are just a small piece of a bigger, more aggressive strategy. They're going after the roots, hoping the branches fall one by one. Another common tactic is the argument of need. You've probably heard the line, "No one needs more than 10 rounds," or "Why would anyone need an AR-15 for self-defense?" But here's the problem, constitutional rights don't hinge on what someone else thinks you need. That's not how rights work. In a real-world self-defense scenario, you don't get to script how many threats appear or how long the encounter lasts. People don't carry 15-round magazines because they expect a shootout. They carry them because being underprepared could be fatal. The idea that your rights are limited to someone else's judgment of necessity is dangerous. Once we accept that the government can dictate what you're allowed to need, it won't stop. 10 rounds could become 5. 5 could become 1. Eventually, you'll be told that a single-shot firearm is good enough. This isn't about reducing crime or enhancing safety. It's about expanding government authority and diminishing your ability to push back. So the next time someone tries to justify a restriction by saying, "You don't need that," remember, the standard for your freedom shouldn't be based on need, it should be based on rights. Which brings us to where we are today. Duncan versus Bonta is more than just a case about magazine limits. It's a stark example of how fragile our rights can become when courts put ideology ahead of constitutional interpretation. If magazines can be dismissed as non-essential and excluded from the definition of arms, then so can virtually any other component: optics, foregrips, stocks, rails, you name it. This ruling isn't the end of the road, but it's a major warning sign. Sooner or later, a case like this will make its way to the Supreme Court, and when it does, the very meaning of arms under the Second Amendment will be up for debate. That definition will determine how much or how little freedom we actually have. What can you do? First, stay informed. Follow these cases. Support organizations that are fighting for your rights in court. Share information like this so others understand what's really at stake. But most importantly, don't stay silent. Rights are like muscles. If we don't use them, they weaken. The Second Amendment isn't self-sustaining. It depends on people like you and me to defend it. Thanks for watching. If this video helped you understand what's happening, give it a thumbs up. Drop your thoughts in the comments and check out our other videos to stay up to date on these critical issues.